Good morning, Beta Beta. You hanging out with us today? You hanging out with us today, girl? Because I miss you, honey. We miss you in the chat. I know I was behind you for a minute, but now I think I'm at least caught up with you on this here case. All right, we're gonna set us the super chat goal today. I'm getting all of our things together, y'all. Good morning, good morning, good morning. I'm about to share this over. It's like I guess I always kind of like never really paid attention to how many people we actually had like watching. But now that I don't stream on Twitter, it's like, oh my God, we don't have that many viewers. So we gotta get our viewership up, y'all. We gotta get our viewership. I want to get that bone. My mom is so hungry. Don't do that. Sorry. Okay, I'm going to share our live. Going to my X account. So I know y'all saw the ending of TK trial yesterday and how he got sentenced to 8 years. To be ran concurrent though. To be ran concurrent. Let me see if I can get. I got 5 minutes. I'm gonna go over to TikTok and see if our folks over there on the tick want to come hang out with us there. If our folks over here on the talk want to come hang out. It's early. It's me looking raggedy. Yeah, I've been looking raggedy for like 2 days. I need to get myself together, okay? Y'all, we are so close to getting 3,000 subscribers. What's up, y'all? Good morning. Good morning. Good morning. Good morning. So, y'all, I'm on. I see. I gotta get on my TikTok Zoom. I gotta get on my Zoom to let y'all know that like y'all gotta come over to YouTube. Okay, y'all need to be coming over to YouTube. So, what's going on? This thing. I wonder if it's my charging port. Like, what's happening? Y'all got to come over to YouTube because today we are going to be watching the Karen Read motion hearing. So y'all got to come on over to YouTube. Come on over to YouTube. My YouTube link is in my bio. If you go to my bio, it's going to take you right to my YouTube channel. So come on over. We got to get our viewership up. We are also really, really close to getting 3,000 followers. We got 29 right now. Okay. We are so close to 3,000 followers. Now, I got a year-end goal of 10. My goal is to have 10,000 followers 10,000 subscribers on YouTube by the end of the year. So we almost halfway through, and we're not halfway at our goals. So we got to make sure we turn it up a little bit. So come on over to YouTube right now. Come on over to YouTube right now. Link in my bio. We getting ready to watch the Karen Read motions hearing. Now, yesterday we was watching TK, and y'all know TK got sentenced to 80 years in prison. Y'all, what's up, D Wood? He got sentenced to 80 years in prison for his second murder, and that is to be ran concurrently against his 55-year sentence for the other home invasion and robbery that resulted in the death. Y'all, in Texas, it's my understanding that after you do 30 years, you are automatically eligible for parole. So I think he's still gonna have to do 30 years before he can even go see the parole board. But he like 20, like 24. 30 years, he's gonna be like 50. He's gonna be 50 something before he's even has a chance. 50 something before he even has a chance of getting out of jail. So because I watched the TK trial after everybody else, I didn't watch it in real time. What I'm going to do, and I know that somebody specifically asked me in the comments for TK trial coverage. What I am going to do is create a 1-minute recap for the entire trial. All right. I'll get in as many details as I can. I'm only going to hit the highlights, and that'll be my coverage for TK. But I am back. All right. We back watching trials. We back following up on motions, all the good stuff. So the trials that I choose to cover up next will just, they'll be real time. They'll be real time trials. So if you want to watch the Karen Read trial with us, it is supposed to start next Tuesday with opening arguments. However, there is some housekeeping that they have to do, aka we gotta go through some motions. We got to go through some motions before the trial actually starts. So because I'm invested now, we're going to be watching those trials today. Okay. We're going to be watching the motions hearing today. So come on over to YouTube. Come on over to YouTube. Let's listen to it. Let's hear what they're talking about and listen to these arguments. All right. As y'all know, I don't have a firm opinion on Karen Read. I don't really know the details of the case. I don't know what was presented. I don't know the details of the case. I don't know what was presented. I don't know. So I'll be watching with the fresh pair of eyes, giving my perspective and literally just trying to follow the evidence. I'm going to try and block out all of the other context and just follow the evidence and form my own opinion. That's how I will be tackling Karen Read. So make sure y'all come over and watch Karen Read trial with me. Also, my Game of Thrones people, because I feel like we're going to be talking about Game of Thrones on this channel too, okay? My Game of Thrones folks, I'm absolutely dropping another video, and we're gonna talk about these setups, the setup deaths, the assassinations. We're gonna be talking about those from Game of Thrones. I'm gonna be ranking my top 5. So yeah, we're gonna talk about it. All right, y'all. So again, my 12 people who are up early in the morning like me with me. Make sure that you all come on over to the YouTube channel right now. We are just waiting for Karen Read to start. So we just waiting. We just patiently waiting right here. All right. I want to say it's supposed to start like right now. So come on over. We over here on YouTube. Come on over. When you come over, make sure you like, make sure you subscribe. Get you a membership. Get you a Taylor Umbridge membership so you can have access to our exclusive Taylor Umbridge emojis. Okay. And today I set up a super chat goal. So come over there and help me meet my super chat goal today. Okay. I got a goal of 10. You can send any color super chat that you want to help me reach my goal. So come on over, engage with us, participate with us, talk with us, and have a good time on this Wednesday. All right. I quit my job to work with my ASD. Oh, JP, I love it. Come on over so we can talk about it. I love that, JP. Girl, come on over. We got to talk about that. All right, y'all. See y'all in a bit. All right. Karen is getting ready to start, y'all. Let's get it. I'm having my morning meeting, y'all, so I shouldn't be too long. I'll get to talking in here with y'all. Is JP in here yet? I'm extremely excited and ready for Karen Read to start because I need to know what the fuss is about. Why are people up in a frenzy, a tizzy about this Karen Read trial? Now I know she's been like super press heavy, but drop down in the comments and let me know why are people so upset or in an uproar about Karen Read? Like what's happening? And how many of y'all actually watched the first trial? Let me know that too. I need to know. Okay, so it looks like it's at least two of y'all in here that has watched the current retrials. 10 of us watching. If you don't want to participate in the chat, that is perfectly fine. I'm just curious why people are such in an uproar. Y'all say it's because she's being framed, child. Who is framing her? Child, he was hanging out with police that went in his department. Now that's interesting. Hmm. So was John also an outsider? I mean, how are they hanging out with people they don't know? What's going on? Sonya, hey, I haven't seen you in forever. Everybody, okay, y'all said she was set up. But if the defense is arguing that somebody else killed them, they don't necessarily have to give, nobody actually has to give a motive in a trial, right? So it's nice to do to paint a better picture for the jury, but that Beta saying they never talked about it. Why they was beefing? Well, how did they hang out? What was going on? Oh, so Karen was the outsider. So her boyfriend knew them. Good morning, loving. How did he know that they was already hanging out though? Y'all like, I'm lost. All right, Wayne. The son was okay. So who had a son? Y'all know I'm getting caught up to speed because y'all know I don't know. So I'm literally just gonna be watching, find out who these people are as the trial goes on. Like I won't know. I won't know what's happening. But I just know people get real serious in comments when I do be trying to catch up, and I just be like, I don't understand what's going on. They started at a bar. Yeah, I'm super interested in open arguments. Like I need them to paint the picture. Tell me what happened. The Alberta have a son. The Alberts. I think they beat him up in the basement and drug him outside in the yard, and that's why they tore the basement floor up and eventually sold the house. What the hell? D Wood. When did this happen, y'all? Was Karen complacent? Do y'all think she had any role in the unalivement? Or do y'all just think it was fully these guys? Mm. Wait a minute. The dog was revoked. What does that mean, Yaya? Mm, mm, mm. They was all alcoholic. Ugh. Renamed, rehomed. I don't think she knew it all. And okay, so now, so we got drunk white people. No offense to my white followers. I love subscribers. I love y'all. We got drunk white folks though. We got a body. We got a car. We got a dog, and we got drugs, and we got a home. We got a house where the floor was tore up and sold. Where is Chloe? She ain't been in here since we've been back live. If y'all see Chloe in somebody else chat, tell her I said I need to see her. And the pool, they poured cement in it. Why would you cover up the pool? They had like an in-ground pool that they poured cement into, and then nobody went and dug up the pool. Yeah, I can't wait. I can't wait. She said, "You got it." Tats and Clouds in the building. Make sure y'all show Tat Clouds some love. I think Chloe is in the pool. Wow. Now Chloe is not our Chloe that be in the chat. You talking about a different Chloe then, right? What's going on? Help me. Wait a minute. Wait a minute. Chloe, so it's two dogs. Okay, wait a minute. Wait a minute. Wait a minute. Wait a minute. Because y'all just lost me. Now y'all didn't told me that the dog got rehomed. Is the dog rehomed? That can't nobody find the dog in the new home? Baby, why you laughing at me? Because I'm very serious. Chloe was the name of the killer dog. But y'all told me that the dog got rehomed. So if the dog was rehomed, somebody can go get the dog, right? But y'all also just told me that Chloe was the dog was in the pool. So y'all gotta tell me if the dog is unattainable. Can they produce the dog? No, one dog named Chloe. The Alberts say she was rehomed, but I think she's in the pool, and that's why they filled it with semen. So I'm taking it as they can't produce that dog because if because okay, so y'all know I don't really know what's going on, but I will say that it was at least one motion hearings that a hearing that we watched. I think it was a Dober hearing where they were trying to um get the dog bite expert in. So I basically I'm assuming that the defense has brought up that the wounds that he's obtained came from a dog. And I would think they would want to match the dog that they have in question to the bites on the human. Like that would be the logical thing to do. So they have not been able to produce the dog. Oh my God. They don't know where the dog was rehomed at. They have document records of where they send people dogs to. What they do, take them to the why they get rid of the dog? The man, oh Lord, y'all. But the state say those might not be dog bites on his arm. Right. I did like see somebody saying something about maybe another animal or anything, but I would expect like I haven't seen the injuries, right? So I'm just speculating, going off of the little information that I know. But I would expect if he was hit by a car, right, he's gonna have scrapes. And if you are bitten by something, you have like a puncture wound, right? Like something goes deep into the skin. Oh, she's available. I mean, how different? My question is just like, how different are dog teeth? Are they like a fingerprint? Like each dog's teeth is different, like a human's. You know how you can be identified by your dental record? Is that the same of dogs? The Alberts has a lot to do with this case, and the police are covering for them. Hey, good to you. Good morning. I have one question. Is it official as to when the current retrial will start? If not, what are you going to do in the meantime? Great question, CB. Right now, they are anticipating having open arguments on Tuesday. Apparently, they've got to get through some housekeeping. We've got today, which is Wednesday. We've got tomorrow. And then remember that Friday is Good Friday. So I'm actually not going to be streaming on Friday. I'm going to enjoy that holiday. Then we've got Monday, and then hopefully opening arguments on Tuesday. I would hope that if they get through all of the motions today, that we will find out or at least hear if they, solidify that Tuesday date. If in the meantime we need something to watch, I'm sure I'll just poll the folks and see what they want to do. I'll see what y'all want to do in the meantime, in between time. I hear Lori is a mess, so I wouldn't mind watching a little bit of Lori, seeing what she got going on. It definitely looks like a dog bite. And D Wood, I think they beat him up and left him outside to die. Taylor, one of the wives, Googled how long to die in cold. And from the house? Okay, so here's my thing. I guess I'm like jumping ahead. I'm jumping ahead, but I don't want to form an opinion. So I gotta kind of limit what I ask. But I got questions. I got questions. Science said free Kern. Lori is crazy. That's what I've been watching. I I heard Lori is something else, baby. You want to tell us a little bit about what's going on over there with Lori? What's going on with Lori, y'all? Tell me who Lori is. All right, now, Karen, let me see what's happening. Let me go ahead and go on over here and check what's happening over on Twitter because that's where I be getting all my information from. I wish we could like just download quickly, like what the heck be going on? Okay. I'm in the courtroom for a final motions hearing before opening statements start next week in Karen Reed's trial. The hearing is running late and it will start at 10:30. So we've got about 3 minutes and the hearing is going to start. So put a little note up here. Okay. She says she's defending herself, and you clearly see she don't know the law. The judge is consistently telling her not to testify when doing cross. She keeps saying my husband, but you married Chaz also. Oh, wait a minute. Did she unalive her husband or something? What's going on, baby? She got two husbands. They say Lori is losing her mind. Charles is the husband. Her brother killed went to get his son, JJ. Lori took Charles' cell phone and wouldn't give it back. Wait a minute. So her brother unalived her husband and she took part in it? Not yeah, that sounds messy, girl. I would love to hear the open argument so I can understand what the state is alleging in that case. So we might have to watch that, CB. Do you have a recommendation? Is there something that you would want to is there something that you would want to hang out and do? All right, y'all. I'm hoping that we're gonna start here in a minute. Let me check Christina's. That was the last update. So we shall see, good people. We're just waiting. They have yet to start the audio, y'all. So whenever the audio starts, it should just come on. Yeah, it's not me. It's the feed. Everybody say, what's up to Bama girl? It's been a minute since we seen her. I'll refresh and see if it'll fix it. Okay, so it's not just us, y'all. It's the feed. I don't think that's what we're trying to get at. I think we're expecting the business logic to work the way that it does. But if because they have such a weird population, if there's someone who fits their condition and they're not in the audit, we need to have that conversation with them. I think that's what we're getting to. Hey, Mickey. It's not me, y'all. It's the feed. You could look at whenever it's not me. Try local Boston network. Okay.
A seminal issue at trial.
Court TV has the audio,
expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that be properly imaged for our review.
Okay, thank you, Mr. Bryan.
It seems the defense characterization that's forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been denied that request. in the
Okay, so
past.
I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view, she can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and
fine.
the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway? All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay,
I will do that.
all right, thank
Thank you,
you.
Your Honor.
Okay. So Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor rep parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition, Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear next.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because.
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right. Thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay,
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive on what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes.
give
We'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank you.
all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes,
So-
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay,
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
all right. How are you going to find this person?
But we could have somebody playing clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
Let's do a sidebar. Bev got that strong Boston accent. I agree. So they talking about bringing
Your Honor,
close.
thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively,
Okay.
we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages.
Come on,
As we all
argument.
know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery, paper 638, Jimmy. All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for for any consideration. So with that, I would ask the court to allow the motion with regard to 3 and 4. I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office of the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but
What do you think a timely manner is?
What ballpark are you talking?
when I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point, that this is not responsive. Their discovery deadline has passed. And so I would like to talk about, or respond after Attorney Jackson is done, about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is. They
So
desperately
address
does
number
not
one,
want-
please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's
So
satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinchler talked about what he did, which was more on the biological
I
side.
get there was a difference between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Right. Ms. Lynn I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can
So-
they testify as to what they did?
Yes. Yes, that's on the
Can they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Councilor Tagbar, please?
They having a long sidebar. A long sidebar. Boy. What is going on in that courtroom? Let me tell you. So what I feel so far is that these folks are gonna argue to the T in this case. Like, I am extremely pleased to know that we are going to have good arguments. I feel like some of the last cases that I've watched, and maybe it's just been a long time since I've watched, but I don't feel like I've been hearing great arguments being made from attorneys. And so I am excited to watch this trial because I want to hear the lawyering. Like, I want to see great lawyering from your side. Like, again, y'all know I haven't chosen a side. I don't know. I will be following the evidence, but each time these attorneys have gotten up, I felt pretty good about the arguments that they were making. I think that it does put the judge, I'm seeing y'all call her Bev, so I think it kind of puts her in a weird place. So I'm interested into seeing how she rules. Again, I don't know. Beta said it depends on how Bev is feeling. You never know with her. So I'm curious.
All right, so Mr. Jackson, you're saying that the ACRA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACRA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There
All
were
right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then
From
you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so
So
when did
that's
you
what we
do,
provided to them.
when did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26th, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I
said-
didn't say 3 days. I said, I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right,
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
all right. Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welcher's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until March or February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Okay, my good people. Okay, my good people. Brennan is swift with it. We were just in the chat, just kind of talking about Jackson versus Brennan. So if you just kind of popped into the chat, I didn't watch the first Karen Reed trial, so I'm getting up to speed as we get ready to enter into the retrial. I haven't formed an opinion. I've asked a few questions, but I am going to follow this case by the evidence that's going to be presented. But I did make some remarks around the prosecutor and the defense attorney who have been arguing, and I think that we're going to be in for a good legal show when this case goes out. I say that lightly because at the end of the day, John O'Keefe did lose his life, whether Karen Reed was the person responsible or not. So just please don't think that I am insensitive by saying that we're going to be in for a good legal argument, because I will be watching this from that perspective, right? I'm never remiss to the sensitivity of the matter, right? It's somebody's life. So, but it was interesting that D. Wood just shared that the prosecutor sitting at the table with the glasses was the lead prosecutor in the first trial. He's soft-spoken, and that Jackson ran all over him in the first trial. I can see that. But it seems like Brendan doesn't back down. Like he's coming back with smart, sly remarks, and so I'm enjoying listening to him pick apart the arguments of the defense. Excuse me. I'm actually gonna back it up just a little bit because I feel I missed a little part of. We're on a 15-minute break. I need to put that in her, but I missed a little bit as to what our girl is trying to argue, and so I want to know what she said she submitted and what she didn't.
Affairs investigations.
Yes.
Was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you. I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see
Okay.
whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Okay, so did she say it was 4 officers or 5 officers? I'm sorry, I'm gonna run it just a little bit back again because
To exclude, but the last I had it as, it wasn't under advisement. You were going to figure out, I need that.
Morning, they're seeking to exclude everything. Commonwealth was conversely ordered to provide notice to the defense.
It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything.
what was these officers
I would like to be
doing?
heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in
4.
this case.
You
Okay.
know what? I do need,
So the officers, y'all got questions. Y'all gonna have to help me fill in the blanks because a motion in limine pending the internal affairs of 4 officers. And so it sounds like the defense is wanting to bring in things that went on. Was this internal affairs investigation conducted in relation to this case, or is it just things that these officers did? And I'm assuming that these are the officers that was at this party in this house. Because it sounds like Brennan is arguing that you can't impeach with a third party statement, basically saying that the investigator statements can be used to impeach one of the officers if the officer is going to be the person that's testifying. Because it sounds like they're going to get them on the stand asking them about their conduct. I could be wrong though. Y'all know I'm coming into the ass end of this. So come on now. Who in here following with me? We gotta have a little dialogue. And that was Attorney Little. I apologize. Victoria George is the former juror and is sitting at the end of the table. Okay. Okay. So Attorney Little is the person who was arguing. Okay. And here's my thing too. Why y'all trying to remove the sequestrature? Because my understanding is that that's the sequester that is only out there for the officers who testify. They sequester them. Basically, you can't sit back in the jury. You can't sit back. You can't sit in on the case, on the trial. So why are they trying to remove it? Did they have like some jury intimidation or witness intimidation going on as it relates to these officers? Like, what's up with it? The fact that they're being sequestered, and then two, the fact that you want to have somebody remove it, like that's a little to me. I'm just talking to myself. It's all good though. It's all good though. Child, I wonder if I can go out here and look at their motions. Let me see if their motions were filed. I want to see. I'm gonna go out here and see if I can find this motion in limine. Cause baby, what? I'm about to get out here and see if we can find this because I'm curious. Search the docket. Let me search the docket. I'm not a robot. Okay, what court division is Karen in? She's in the Norfolk Superior Court. Let's see. And she's in Norfolk. Mm-hmm. Okay, now this is not the Superior Court. This is the regular. This got to be regular. Let me see. Taylor, we should watch the opening statements from the first trial. Let's do it. We can look at that. We can definitely look at that. That's a great idea, Beta. I think they are trying to do that because of them working together to change the actual. Yeah, sticking to it. She said they was working together. Trooper Proctor got fired. He testified in the first trial. See, I heard a little bit about him. He was the guy who was talking about the nudes, right? No, John's family was jury intimidating the first trial. They friends and believe the cops. Oh, Proctor was definitely a friend of theirs. Beta, I agree. That would help to you a lot. Yeah, we're gonna watch the opening statement from the first trial. We for sure gonna do that. I'm trying to pull up this. I'm trying to pull up this motion, y'all. I want to, cause I'm anxious. I'm anxious to see. Hold on. Sorry, y'all. So story time. So my grandmother has dementia, y'all. So okay, so she started out fine, okay, but the disease has started to take over her. So she kind of has like her episodes or whatever. So they just called me to tell me that okay, let me back up a little bit. So my cousins live in the house with my grandmother. Because we don't want to put her in the home. So they stay in her house with her to take care of her. Yeah, my granny then told them that they need to go to the store and get her some Morgan David. So they just called me talking about, yeah, your granny said she wants some Morgan David. And we need to go get her something to drink. Yeah, first of all, it's 11:30 in the morning. Number one. Number two, you all will not give her any wine. I don't care. She will not have any Morgan David today. Just a quick little funny while I was off the mic, but my grade trying to get lit this morning for whatever reason. Let me see if somebody posted because I know Katna Williams, she usually posts a lot of the motions. Let me see if I can go on her page and see on Twitter. And see if she's got it posted out here. Here she goes right here. Kate usually posts a lot. I'm like I said, I'm searching for that motion to limit on the pending internal affairs investigation because I need to know. I need to know. Okay, she posted some Right Street stuff. Let's see. Get her stuff. Y'all out here trying to get my granny lit on this here at this. We don't got time. Let me tell y'all, I'm trying to. So one day, now we try to find the humor in everything, y'all, because it really like, you know what I'm saying? It's really heartbreaking. But one day, my granny kept on saying that my cousin, we gave her a cup of water. And now I was there right before my cousin came. I had just left. And so then we had gave her a cup of water, and I was there when she got the water. She's sitting down. She didn't told them that my cousin then gave her some alcohol. So she was sitting there acting drunk, y'all. She was sitting in her chair acting drunk. And I'm like, they calling me. I'm like, Granny, I gave you some water. Like, we gave you water. It wasn't no alcohol in that cup. Yeah, she couldn't walk or nothing. It was hilarious. It was the funniest thing ever. They were showing me, we had a little FaceTime call, y'all. She was acting so drunk. I'm like, my granny has literally lost her damn mind. Thankfully, she does still come back around. She does still come back around every now and then. She ain't completely gone. Does she experience sundowning? She does. She's starting to experience it. She's like really early stages of it though. So yeah, it's kind of been our experience. So nope, I can't find it on Cat Page. I gotta figure out case documents. See, I'm on the Supreme Court. I need to get off of her. I ain't trying to get on the Supreme Court. I need to just be inside of the state court. Now, I ain't trying to pay Massachusetts to be civil cases only. Searching by case type. All right, let me go back up here and see if I can do this. Trial court. Okay, here we go. It may not include the most recent. Okay, let's do a search. Let me see. Maybe I got the wrong results as to where her case is. It is a superior court, though. So why y'all ain't give me what I need? It don't even have like a beginning date, an end date, nothing, y'all. Katna Williams does some amazing work on her page. Like, she really does some great reporting. One of my aunts had dementia. I know how it is. Trust me. Imagine I remember. I'm so happy y'all keeping Granny home now. Yeah. And the thing is, like, she can't walk very well. So we had to move her room from upstairs to downstairs so that she could stay at home without having to put her into a home. Now, there was a point in time where she actually did want to go live like in an assisted living facility because she felt like she missed the community, right? My grandfather, he passed away like, how old is Samaj? Samaj is 11. So he passed away. He been gone for 11 years. And I think once she kind of started having like health issues, it really took her away from the community that she kind of had and that she wanted. And so she did talk about it for a while, but we never let her go because she had dementia, and she actually does not like the dementia medication. So she is unmedicated. So yeah, that's where we are. Y'all, I have found.
Think about that part.
Okay.
I'll be back.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay,
That's the audio, but there will be the visual with it that was aired.
okay. I was able to see the video.
Super.
Okay.
Work.
All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to council. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
It's
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses
seeking to question people is witness
Okay,
intimidation.
so just focus back on.
So the
this.
answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Oh, I see. She's a breaker. She's the breaker. Okay, now y'all got to get me up to speed on this free Karen movement. Who the hell is Turtle Boy? He's a YouTuber leading the free Karen movement. Y'all, what do Turtle Boy be talking about? I got to go out to his page. Hold on now. I got to see what Turtle Boy be talking about. And I mean, he come right up in the search bar. Colin and Chris Albert's visits to Kenton Pete. Like, this man got a whole. Wait a minute, y'all. Okay, I'm about to show y'all. Okay, we on his. We about to get on his page. He got 107 subscribers.
I'm Aiden Carney of Turtle Boy Daily News. I've been investigating the death of John O'Keefe from Canton, Massachusetts. His girlfriend, Karen Reed, is charged with his murder.
Karen, just to be clear, you didn't do it.
That's the view it would have gotten.
But is there something more going on here? Is Karen Reed the victim of a massive cover-up? During my investigation, I have uncovered a town full of corruption. Here's what I believe happened, and why I believe Karen Reed was framed.
Don't you want to ask some questions? I know you do.
I do. I have
know
been.
you do.
I have. You think that you could outsmart Karen Reed? Did you? It's. How can you wear those buttons when you covered up his murder? Any comment on that? Why you Googled that 227? On the morning of January 29, 2022, Boston police officer John O'Keefe was found dead outside of the Canton home of Boston Police Sergeant Brian Albert on 34 Fairview Road. O'Keefe's girlfriend, Karen Reed, was charged with manslaughter after reportedly backing over O'Keefe with her car after she got into a fight with with him and dropped him off at Albert's house after a night of drinking. She was castigated widely as a cop-killing villain, set to face decades in prison. But as it would turn out, at least a dozen people were in the house when John O'Keefe was being violently beaten to death before hatching an elaborate plot to frame Karen Reed for killing him. The cover-up was aided and abetted by members of the state police, the Canton Police Department, and the Norfolk County District Attorney's Office. This is the story of one woman alone, facing down some of the most powerful, well-protected people in the state who sought to destroy her life and exonerate herself. This is Karen Reed and John O'Keefe. Karen is an intelligent, successful accountant and college professor with not even a hint of a criminal record. She'd been dating John O'Keefe for several years.
I'm gonna
and
stop,
loved
y'all. I'm gonna stop. I'm not gonna go too far down the rabbit hole because I don't want to get I don't want to get an impression. But child, yeah, my browser lost connection. Can y'all still hear me? Can y'all still hear me? Dirty cops, not surprised. That man called out 3 separate police departments. Let me stop my share. Hold on. Stop sharing, and then I'm going to reshare. I'm going to share again. So it says something happened with my... Okay. As long as y'all can hear me, then we good. That man called out 3 separate police departments. He said, oh. She said, yes, we can. Yes, we can. Wait. Y'all, my mouth is on the flow. And so the prosecution wants to bring him in for what? Oh, okay, you can hear me. Yeah. Okay. Sweet. So why does the prosecution want to bring him in? Oh, okay. I'm seeing beta because he analyzed the first trial and him and Karen was texting. Him and the prosecutor wanted they text messages. Well, they thought that she was going to admit that she did something with him. This man felt, oh, child. Let's see what other videos he got on his page. I mean, everything is Karen. Okay, now he got some other stuff on her. Okay, so he does trials of the Norfolk Superior. So he must be from Massachusetts. That man said, I was investigating the Karen Reed trial. He said, forget what y'all done did. I'm going to get out here and investigate. And I'm going to let y'all know what my findings are because I didn't figure it out. Forget a police department. I got this. They allege he was also intimidating witnesses. Well, if that lady was the lady who Justice for JJ, he said if that was a sister that y'all claimed text how long to die in the code, if that was her, I would say that was a little bit witness intimidating and intimidation. Yeah, end of the day. Yep, that was her. Yeah, somebody could read that as being intimidating. That's why vigilante work is hard. You gotta really watch yourself when you cover trials like that, and you got the goal to be aggressive with people because charges can come behind that. Now I see why he intends on pleading the 5th because I sure was sitting here thinking like, well, what he need to plead the 5th for? Well, I ain't gonna lie. At first, I thought he was pleading the 5th because he was an officer. But when y'all explained that he was a blogger, yeah. Yeah. He definitely needs to sit down somewhere. He got to get out the way. Got to get out the way. Yeah, that's too much. You can't be approaching people like that. You could be a catalyst in one of these situations where you where you know what I mean, where you have to, pressure somebody into saying something that could mess up the case. You definitely don't want that. Mhm. You definitely don't want that. Yeah, I'm still out here trying to find that motion. I'm still trying to find that motion. I did find the court number, the case number though. I did find the case number. Let me see. Yeah, I just don't know how to look up her case stuff. But the motion of limine for pending internal affairs, like I want to read that. I'm not even on front. I'm gonna make a Twitter post and ask if is anybody keeping a copy. Yeah. I'm gonna put an APB out on I'm gonna put an APB out on Twitter. All right, 1 second, y'all. Somebody at my door. It's probably my lunch. All right, y'all, back. He said, "How you wearing giant buttons and y'all covered up his murder?" Yeah. He works with Turtle Boy too. He be having a lot of emotions too, Taylor. Is that his screen name, Beta, the DUI guy? If that's his screen name, I'll go out there and try to find him. Where's Che at? Che, you still in here? Okay, let me see if I can find him. Let me see if I can find that person. I'm still looking, y'all. I'm still looking. I'm struggling to find it. Incorrect. That was McCabe's turtle. He was talking to in that video, not the Alberts. I'm gonna get the opening arguments queued up too, though, Beta, because I definitely need to go ahead and get my little stuff together. Was opening arguments long in the first trial? Wait a minute, Chloe. Because now I'm hearing about this dog named Chloe and Alberts. And now I'm looking at your name and it's Chloe Alberts Revenge. And I feel like your screen name is directly related to this case, Chloe. What's going on? It's the mathing. Chloe, I was just talking about you this morning. I said, where is Chloe at? Because she ain't been in here since we've been back live. What happened to Chloe? It's nice to see you. Beta, it's a motion in limine for the pending internal affairs investigation. I don't know what the name of it would be, but it would have been filed by the state or the Commonwealth, excuse me. I got to get used to saying the Commonwealth now. Well, Chloe, you know I didn't watch the first trial, so we gonna watch opening arguments here, so I can get a better foundation.
You are unmuted.
Court is
Here we
back in
go.
session. You may be seated.
Hi, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to consider his Fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel.
Thank
And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
So it sounds like he's about to put his pleading of the Fifth on the record, but we're not going to hear it. She said, Taylor, as an aspiring attorney, this first trial will infuriate you. The judge is completely biased. Well, I'm not going to watch the whole trial. We're just going to watch the opening argument ahead of Tuesday. Because they say Tuesday, the show going to start. Our show going to be on. And to be honest with y'all, okay, look, if you watch the first trial, how long does she take lunches? How long is lunch usually? Because what we could do, we could start an hour behind the feed. And that way we can watch through lunch. I don't know if I'm gonna be able to wait though. I don't know. But it's an option. So we can have a continual watch.
Yes.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them. Do you, all right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy and
And it is something that we've done.
right. Understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so go, please.
Oh Lord, Chloe, it sounds like we getting ready to have a Glanville flashbacks. But this motion hearing is over, so I'm actually going to switch over to day one of her trial, so that we can watch opening arguments, or that I can watch opening arguments. I know y'all didn't see it. We're gonna see what I need them to lay out this story for me. We're gonna slow it down a little bit too. I had way too much sauce on it. Oh, okay. All right, let me try something. Let me make sure it's not muted for some reason. Y'all know they be acting. It's quiet. Okay, let me see what I can do. Is it quiet?
in violation of General Law, Chapter 90, Section 24(2)(a)(2).
Still quiet.
To these indictments, the defendant has pled that she is not guilty and for trial is put
Okay, can y'all at least hear me? Can anybody hear me? Okay, we were good. All right, let me go ahead and get us back.
upon the country, which country you are, and you're sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you are to say so and no more. Jurors hearken to the evidence.
Thank you very much. Will counsel identify yourselves, please, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Morning, Mr. Lally.
Morning, Your Honor. Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor, and ladies and gentlemen of the jury. My name is David Yannetti, and I represent Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, good morning, jurors. Before we begin, I have to ask you 3 questions that I'm going to ask you every single time we meet. The first question is, were you all able to follow my instructions and refrain from discussing this case with anyone? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we were last in court? No. Everyone said no or shook their heads. Thank you. All right, jurors, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you'll hear about during the course of the trial. But these comments are not intended to be a substitute for the more detailed instructions on the law, which I will give you at the conclusion of the case. This is the trial of a criminal case, as you've heard, and you've heard that the defendant is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe in detail at the end of the case each of these indictments when I teach you the law, but briefly, murder is the unlawful killing of a human being. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. Again, these terms and elements of the crimes, including the additional crime of leaving the scene of an accident after causing personal injury or death, will be described for you in detail at the end of the case. Please remember that the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. So it's merely a formal manner of accusing a person of a crime to bring her to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish with these initial instructions, Mr. Lally will make his opening statement. Ms. Gianetti can choose to make an opening statement or not, because the defendant has no burden of proof and doesn't have to prove anything. Her lawyer doesn't even need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended to introduce the main issues in the case. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but again, she is not obligated to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. You see that we have many of you. We have 17 of you, and only 12 will ultimately decide this case, and that's done at the end of the case. We impanel so many jurors in a case that's going to take a long time in case something comes up and a juror can't complete his or her service. Let me talk briefly about our respective roles in this case. As the judge, my responsibility is to see to it that this case is tried in an orderly, fair, and efficient manner. It's also my function to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. The jury's function. You folks are the most important people in this courtroom. You determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consult receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, you must ignore it so that only that you keep your voice up, please.
Do my best. Good morning. So as Her Honor was telling you, this is one of the two opportunities that I will get to address. The first of which right now, essentially what I'm going to attempt to do, and I know you've heard over the course of the impoundment process a number of different witnesses that were listed out as far as potential witnesses in this case. So what my intent here is to provide as much of a roadmap as I can through those waters and help you to navigate sort of who these people are and what relation they have to this case. We start with John O'Keefe. John O'Keefe grew up in Braintree. He was 46 years old when he passed. He was the son of John O'Keefe Jr. and Margaret or Peggy O'Keefe. He was a brother to Paul O'Keefe and to his sister, Kristen Furbush. Kristen was married, and so John's brother-in-law was a man named Stephen Furbush, and they had two children who were very young in 2013. Now, in 2013, Kristen, unfortunately, tragically, passed away, succumbing to cancer in November of 2013. Within months of that, Mr. O'Keefe's brother-in-law and Kristen's husband, Stephen, passed away as well. Now, initially, when John O'Keefe's sister passed away, sort of the initial plan for that situation was that John O'Keefe was going to move in with Stephen Furbush and kids and assist as far as raising them. And then when Stephen passed away a few months after his wife, before those plans could be finalized, John O'Keefe then moved in with his niece and nephew and assumed the parental role and assumed legal guardianship with respect to both of those children. Now, he was assisted in this by a great number of people within the town of Canton where the Furbushes lived and where John moved into the home with the two children there. There were other parents within the neighborhood, other parents within the children's age group. You'll hear from a number of them over the course of this trial, but they include Mrs. Carrie Roberts and Mrs. Jennifer McKay. They helped Mr. O'Keefe out during those initial stages and during the time that he assumed this role. He also got help from his work. John O'Keefe was a proud member of the Boston Police Department, had been for many years. He had been a patrolman prior to moving in with children and assuming this role. Boston Police Department helped him greatly as far as positioning him as more of a desk role, working in the sex offender unit with more regular hours to sort of assimilate himself to this new life and this new role that he assumes with his children. Initially, John O'Keefe lived in the house with kids. However, in 2018, they moved into a new home, sort of a new home that they could have as their own. That home is located also within the town of Canton, sort of on the Stoughton side of Canton at One Meadows Avenue. John O'Keefe raised these children, assuming guardianship for them for about 8 years. His niece, who was the elder of the two, was about 14 at the time that John O'Keefe died. His nephew was about 11 years old at the time that John O'Keefe died. January 28th, 2022 was a relatively typical day. It was a Friday going into a Saturday of January 29th. Sort of typical in the sense of most sorts of urban parents. There were a lot of activities, weekend sports, practices, games, things of that nature that the O'Keefe and Furbush family had to look forward to. One little difference when it came to that particular day of January 28th and the 29th is the weather. So there had been predicted and there was going to be a snowstorm, an insignificant one. a blizzard essentially was coming in overnight that Friday and Saturday, lasting through most of the day on Saturday the 29th. And as a result of that, most of those sort of typical, weekend routine activities that would keep most people, including those within the town, staying busy, have been canceled. And everybody knew what was coming. Everybody knew essentially you weren't going to leave your house all that much the following day. Now, also on January 28th, Mr. O'Keefe had received some news in respect to his niece. So his niece and her best friend were in 8th grade at the time, going to high school in the fall of 2022. They both applied to a private school called Michigan, and they both found out on the 28th that they had been accepted to that school. So the friend, as well as her father, a gentleman by the name of Michael Camerano, who's both he and his wife, Catherine Camerano, were friendly with John O'Keefe. They had children around the same ages as both John's niece and his nephew. And they had come over to their house on Meadows Ave that evening to celebrate girls getting into that school. The nephew of John, the 11-year-old, was sleeping over a friend's house that night. He left at home sometime around 7 p.m. or so, got picked up and went to sleep over at his friend's house. John O'Keefe and Michael Camerano then decided to travel out to a local establishment on Washington Street called C.F. McCarthy's Bar and Restaurant. You're going to hear testimony, and you're going to see surveillance video, and you're going to see receipts and all kinds of things from a variety of different establishments, all sort of located within Camden Center along that strip of Washington Street. Now, they get Mr. O'Keefe and Mr. Camerano leave the girls at home. They then go to C.F. McCarthy's, arriving there sometime between 7:30 and 8 p.m. They eventually cajole another friend of theirs, Mr. Kurt Roberts, to come out to the bar and join them as well. And there's some other people that are located within the bar, including Mr. James Sullivan, who we hear from, who was present at the bar that night as well. Eventually, the defendant, Karen Reed, joins them at this establishment, C.F. McCarthy's, sometime just before 9 p.m. Now, John O'Keefe and Karen Reed had met sometime in 2004. They had dated briefly during that time and reconnected sometime around March of 2020, around the time of the COVID-19 sort of pandemic shutdown. They had started dating around that time period, or reconnected during that time period, and the defendant had stayed at the house in Canton several nights a week. She had helped out with the children. In the month or so leading up to Mr. O'Keefe's death, the relationship soured. You will see text messages between Mr. O'Keefe and Ms. Reed to that effect. You will hear testimony from the children, from John's niece and nephew, in regard to things they observed within that relationship. And you'll hear testimony from other individuals as far as their observations or things that they heard. Turning to January 29th, 2022. Just after 6 a.m., Canton Police Department receives a 911 call from a woman reporting a male party, subsequently identified as John O'Keefe, found in the snow outside a residence at 34 Fairview Road. At the time, as I mentioned, blizzards that had been predicted was occurring, heavy snow, temperatures in the teens, wind bustling around. Officer Stephen Saraf and Officer Stephen Mulaney of the Canton Police were dispatched along with Canton Fire and EMS, and you'll hear from them in regard to their response to what they observed on scene. In particular, with Officer Saraf, who have as an exhibit anticipates a cruiser camera video from his cruiser detailing or memorializing sort of his response in the darkness, in the blizzard type conditions as he's driving from the Canton Police Station, where he was located when he received the call, to 34 Fairview Road. When they arrived there, they observed three females, sort of off to the left side of the property. When I say the left side of the property, I mean if you're standing out in the street facing 34 Fairview Road, off to the left side of the property, there's a flagpole, there's a fire hydrant, there's some bushes. That is where Mr. O'Keefe is located. On the right side of the property is sort of the driveway and the mailbox, other things that you'll become familiar with through photographic evidence and other means, of course, of this trial. The three females that the officers observed there were then identified as the defendant, Karen Reed, Mrs. Jennifer McCabe, who received a phone call earlier in the morning from the defendant, as well as Mrs. Terry Roberts, who would also receive a phone call early that morning from the defendant. The several firefighters from the Canton Fire Department you'll hear from in regard to their observations of injuries, abrasions, and lacerations right on with Mr. O'Keefe. You'll hear their testimony in regard to swelling of his eyes and other injuries that he observed. They observed redness from the cold that he had been lying out in for some time. You'll hear the testimony from these firefighters, Timothy Nuttall, Anthony Flamati, Matthew Kelly, Francis Walsh, Katie McLaughlin, and Greg Woodbury. And at least from three of those firefighters, you'll hear testimony anticipates detailing statements that the defendant made to them when they had asked about the origination of some of those injuries. And stated repeatedly, I hit him, I hit him, I hit him. Mr. O'Keefe was then taken from the front lawn onto what they call a scoop stretcher as he's doing that, I anticipate you'll hear Ms. Roberts' testimony that despite the 6 inches of snow approximately that was on top of Mr. O'Keefe's body and the snow throughout the roadway, front yard, everywhere around where he was, there was grass underneath Mr. O'Keefe, where his cell phone was located underneath his body as he lay on that front lawn. He was then transported by firefighters Kelly, Zamati, and Nuttall, as well as the ambulance being driven by firefighter McLaughlin to the Good Samaritan Medical Center. Once there were some observations, and you'll hear testimony from Dr. Justin Rice from that facility as far as observations consistent with what I anticipate you'll hear from those firefighters. But then there is a certain warming procedure that they go through trying to bring his body temperature up. Because when Mr. O'Keefe arrives at the Good Samaritan Medical Center, his body temperature is 80. And after those resuscitative efforts prove unsuccessful, Mr. O'Keefe is eventually pronounced by Dr. Rice at approximately 7:50. Shortly after that, when the defendant is then being driven away from the scene by Ms. Roberts, who is now going to go pick up Mr. and Mrs. O'Keefe, Jonathan's parents in Braintree, and bring them to the Samaritan Medical Center in Brockton, the defendant makes some statements of self-harm. As a result of that, she's then transported to the Good Samaritan Medical Center as well by 2 firefighters named Daniel Whitley and Jason Barrett. And amongst the statements that they gained from the defendant as they're having a conversation with her in regard to that, in regard to her treatment and diagnosis, she indicates that the last that she saw Mr. O'Keefe, they had gotten into an argument before he had gotten out of the car in front of their employee. Now, you'll also hear testimony from some of the other first responding officers from the Canton Police Department, including Lieutenant Paul Gallagher, Sergeant Sean Good, and Sergeant Michael Lent, in regard to their initial response, their observations, people that they spoke to, where they went, and their ability to recover within these blizzard conditions that are still ongoing, certain pieces of evidence that they located in around the area where Mr. O'Keefe's body was found. They will also
shoot, Chloe, my bad. I'm out here trying to write you back. I didn't took the screen off. Sorry, y'all.
Bringing her back to his house as she was left unattended when the defendant left to go looking for Mr. O'Keefe. So unaware of that, they go do a well-being check approximately 8:22 in the morning. And they also have a cruiser camera video attached to their cruiser. You'll see that and when they pull into the driveway in Meadowtown, approximately 8:22 in the morning, they pull in directly behind where eventually you'll hear Mr. McCabe left the defense vehicle after driving into the courthouse to Meadows Ave in search of Mr. O'Keefe. And you'll have that footage, and you'll be able to see the back of the defendant's vehicle, specifically the right rear taillight of that. Now, you'll also hear testimony, as I mentioned, from the Cameranos, from Mr. Roberts, from Mr. Soto. Also, they were all present with the defendant and Mr. O'Keefe at C.F. McCarthy's. You'll hear testimony from a number of other individuals who were at the Waterfall. The Waterfall is a bar located across the street, essentially from C.F. McCarthy's on Washington Street in Canton Center, and somewhere that Mr. O'Keefe and the defendant went after leaving C.F. McCarthy's at approximately 11 p.m. Now, from that establishment, you'll hear from Rebecca Traers, who was working as a bartender at the Waterfall that evening. You'll hear from a couple named Nicholas and Karina Polkaitis, who were friends of friends who had known Mr. O'Keefe through their daughter around the same age as Mr. O'Keefe. Mrs. Polkaitis had some conversation with the defendant that evening, as well as herself and Mrs. McCabe at the Waterfall. She left around the same time as they did. She parked on Washington Street around the same area as Mr. O'Keefe and Ms. Reed did, specifically in Ms. Reed's car. And she observed Mr. O'Keefe and the defendant walking toward the defendant's vehicle, and specifically the defendant walking towards the driver's side. Now, you'll hear testimony from a Christopher and Julie Albert, who were people who were at one point neighbors of Mr. O'Keefe. They knew him well from being neighbors of him. Christopher Albert owned a pizza shop, also located within that Canton Center area. Mr. O'Keefe, earlier in the day of the 28th, had been into that pizza shop along with his nephew to get the nephew a slice. Christopher Albert and Mr. O'Keefe had some conversation regarding what they were doing that night, and it's Christopher Albert who actually texts Mr. O'Keefe and indicates that they're over at the Waterfall and that he should come over shortly before Mr. O'Keefe and the defendant make their way from C.F. McCarthy's home. Now, Christopher Albert left directly from the Waterfall and went home. He was sort of walking distance away from them. His wife, Julie Albert, had left earlier in the evening. There was a band playing at the Waterfall that night. Julie Albert started to get a migraine, and she left before most of the group. Included within that group, and sort of how they came to the Waterfall, the Albert family in particular, Julie Albert went there along with her sister-in-law, Nicole Albert, as well as her niece, Caitlin Albert, her niece's boyfriend, Mr. Christian Morris, and they had had dinner at the Waterfall earlier in that night. Now, Nicole Albert lives at 34 Fairview Road. She has a husband named Brian Albert, who's also a Boston police officer. Brian Albert had gone with a friend of his, who's also in law enforcement, a man named Brian Higgins. And they had gone separately, but had come home together from a funeral for a fallen police officer in New York City. Came home early to sort of beat the weather, and eventually they meet up with Brian Albert's family at the waterfall. Now, Tristan Morris was Caitlin Albert's boyfriend, had left the waterfall at some point in the evening. He then returns later to the residence on Fairview Road and picks up Caitlin Albert, brings her home. All of this is in relation to Brian Albert and Nicole Albert's son, Brian Albert Jr., whose birthday was coming up the following day, the day of the snowstorm on the 29th. So he had been back at the house at 34 Fairview while his family was out at the waterfall. He had a number of friends that had come over that evening to celebrate his birthday with him. Now, among those friends was two individuals named Sarah Levinson and Julie Nagel, and they were at the residence at 34 Fairview for a good portion. Now, those individuals from the waterfall that leave and then come to 34 Fairview, they do so sometime shortly after midnight. Shortly after midnight is when it starts to snow. Flurries are starting to come down. Snow is starting to stick to some degree to roads, to front lawns, grassy areas around town. Now, from that group, the group that goes back is obviously Brian Albert and Nicole Albert as they live there, Caitlin Albert, because it's her parents and her boyfriend picking her up, as well as Jennifer McCabe, who is Nicole Albert's sister, and her husband, Matthew. They go back to that, and there's an open invitation to essentially anybody that's there. John O'Keefe takes them up. There's certain text messages and phone conversations between John O'Keefe and Jennifer McCabe as to where this house is located, as he's never been there before. And then he and the defendant drive in the defendant's vehicle to 34 Fairview. And once there are several witnesses from within the home that observe the vehicle parked in. So I mentioned earlier there were two females that were with Brian Albert Jr. at the house, one of them being Julie Nagel. At some point, she had called her brother, Mr. Ryan, for a ride home. He then gets a ride from his friends, Ricky DiAntonio, as well as his Nagel's girlfriend, Heather Max, that's riding in the back of Mr. DiAntonio's pickup truck. I say that because they arrive at Fairview Road around the same time as the defendant. The defendant is coming in from one direction, the pickup truck with the Nagel brother is coming in from another direction. The pickup truck with the Nagel brothers riding in flashes its light, signaling the defendant to go. She goes first, they follow in behind, and lo and behold, they end up at the same house. They park the pickup truck somewhere in that right side of the property, facing it from the street in the area of the driveway, and the defendant in her black Lexus SUV parks a little bit further up. Different people from within the pickup and different people from within the house observe that Lexus SUV in one location, pull up a little bit further, and then pull up a little bit further until it's in the area of that fire hydrant, of that flagpole, where Mr. O'Keefe is located the following morning. Now, from their position, I anticipate the testimony that you're going to hear is that Heather Maxson from that pickup truck observes a male passenger and a female operator when the pickup truck operator flashes those lights as the vehicles are facing each other before they pull down. What you'll hear also, I anticipate, from all three of those individuals in the pickup and Julie Nagel, who comes out to the pickup to talk to the brother, is that no one ever exits that vehicle. There are no footprints around that vehicle. There's no damage that they observed to that vehicle at that time. Again, it's just started to snow. Things aren't sticking really too much at this point. Julie Nagel has a conversation with her brother, decides that she's going to stay at the house longer, so arrangements for a ride home, and the pickup truck leaves from that point. As they pass by, they observe a female operator, matching what I submit as the description of the defendant. From all of those people within that house that evening, none of them at any point in time observed John O'Keefe come into the house. They see the vehicle up front, they see the vehicle pull away, and they just assume that they left, and that no one was coming. We'll hear testimony from other individuals who were at the house that night, including Colin Albert, who is Julie and Christopher Albert's son. He's also a cousin of Brian Albert Jr., who was having people over for his birthday. He's leaving the house around the time that the initial people coming back from the waterfall, which includes the homeowners, and Mr. Higgins, are sort of coming into the house. At that point, Colin Albert was leaving. He's getting picked up by a young lady named Allison McCabe, who was Jennifer and Matthew McCabe's daughter, who's also friends with Colin Albert and also cousins of Brian Albert Jr., who's within the home celebrating his birthday. As I mentioned, you'll hear testimony from Matthew McCabe and from Jennifer McCabe in regard to their observations that particular evening, both at the waterfall as well as at the residence on Fairview Road. And then you'll hear testimony in regard to a phone call. A phone call that Jennifer McCabe receives from John O'Keefe's niece at approximately 4:53 in the morning. She answers that phone call, speaks to the niece briefly, and the niece hands the phone over to the defendant. Now, you'll hear testimony from the niece as well, that about 4:30 in the morning or so, the defendant came into her room in a frantic state, saying that Mr. O'Keefe had not come home the night before. So initially, when the defendant is talking to Ms. McCabe, she indicates to Ms. McCabe that the last time she saw Mr. O'Keefe was at the waterfall. Eventually, as Ms. McCabe is waking up, she reminds the defendant that she not only saw them leave the waterfall around the same time as herself, but also saw the vehicle, the defendant's vehicle, outside of the home on Fairview Road. Eventually, the defendant, while driving around, this will I mean, as far as other testimony and related testimony as it develops. But she's driving around in that morning. She's calling a bunch of number of different people, friends of Mr. O'Keefe. She's calling Mr. O'Keefe himself. She also calls Mr. Roberts. So Kerry Roberts received a call about 5 a.m. from the defendant indicating that Mr. O'Keefe did not come home, indicating that he got hit by a plow or that he must be dead. Ms. Roberts then gets ready. Mr. Cave is getting ready as well, sort of planning to go out and look for Mr. O'Keefe and see if they can locate him. They call numerous times. You can see that within the text messages and the phone extractions from a variety of people's different phones throughout the course of this trial as well. So eventually the defendant comes to Ms. McCabe's home, indicates at some points prior to that she has cracked hip. Ms. McCabe then gets in the driver's seat due to the defendant's frantic state. Ms. Roberts is there as well. Ms. Roberts follows Ms. McCabe driving the defendant's vehicle back to Mr. O'Keefe's residence in Meadows Ave, checks on the niece. The defendant then shows both Ms. Roberts and Ms. McCabe the damage to her right rear taillight, which is essentially missing a number of different pieces from that right rear taillight. They then proceed off to drive and see if they can locate Mr. O'Keefe. The defendant is insistent that they go to that residence on Fairview Road. Again, they're driving down there in the dark, in the snow, in the wind, in the blizzard. As they approach towards that residence, there's one person, so they're seated within the vehicle. This is Ms. Roberts' vehicle. She's driving. Mrs. McCabe is in the front passenger seat. And the defendant is in the rear passenger seat. The defendant is the only one who sees Mr. O'Keefe. He yells and screams at Ms. Roberts to stop. Ms. Roberts and Ms. McCabe, I anticipate, will testify that they did not see Mr. O'Keefe, not only as they were driving past him, but even after they got out of the vehicle until the defendant gets out of the back seat and makes a beeline essentially right over to where Mr. O'Keefe's body was found. Mrs. McCabe.
All right, hold on. I got
911.
questions. All right, y'all. I got questions because I just heard this man say that Karen Reed texted somebody and said that he was hit by a plow. Was that proven? And then she showed somebody missing pieces of her taillight. Like, is this real? Or these, I don't know. I guess I gotta wait till the next, to next week to figure out like did this really happen. But I'm kind of getting lost in a theory real quick. I mean, I feel like he's putting it on to say like, okay, she knew what she did and now she's trying to cover it up. But at the same time, he just said that 2 people left out of the house that he went in and his body was out in the yard and they didn't see it until she got there. So that just, I don't know. I could be tripping. We do got it sped up a little bit, so I could just be mishearing or some shit. I don't know.
And shortly after that is when the officers and firefighters arrive on scene. Now, while they're waiting there, approximately 6:23, 6:24 a.m., during a conversation with the defendant asks Mrs. McCabe to look up on her phone how long someone has to be out in the cold to die from hypothermia, something to that effect. And you'll hear some dispute as to when that search was made. And you'll hear testimony from 3 different forensic extraction experts, Nicholas Carino, Ms. Jessica Hyde, and Mr. Ian Whitfield. You'll hear about a lot of these things called extraction reports from cell phones. And the extraction reports are done with a program called Cellphone. Mr. Whiffen is someone who writes that software for Cellphone. I anticipate you'll hear from each of their testimonies that Google search that was done on Ms. McCabe's phone was done at the same time frame that she indicates the defendant requested her to do it, and that at 6:23 and 6:24 morning. We'll hear testimony from Ms. Roberts, Ms. McCabe, firefighters, and the responding police officers about a repeated phraseology that the defendant stated while there, asking again and again in regards to Mr. O'Keefe, is he dead? He's dead. You will also hear testimony, as I indicated, about sort of treatment that she received at the Good Samaritan Medical Center, and that would involve testimony from Ms. Daisy Wormseth, Ms. Kathleen Wilford, and Dr. Gary Fowler. We'll hear testimony from a number of different analysts from the State Police Crime Lab and from some other laboratories as well. Included within that will be Mr. Nicholas Roberts, Ms. Maureen Hartnett, Mr. Andre Porto, Ms. Ashley Valier, and Ms. Christina Hannon, those all being from the State Police. You will hear testimony in regard to an incident which occurred earlier in January, right around New Year's. Mr. O'Keefe, defendant, and the children have been invited with a much larger group, approximately 70 people or so, to spend New Year's in Aruba. This is a trip that was organized by a friend of Mr. O'Keefe's named Laura Sullivan. We'll hear testimony from her, as well as from her sister, Ms. Marietta Sullivan, as well as you'll hear testimony from 2 children in relation to this. And essentially, day 2 or so of this trip, Marietta Sullivan, the sister of Laura, is walking through the lobby and she runs into Mr. O'Keefe. This is someone she refers to as godfather because John O'Keefe is also the godfather of Laura Sullivan's son. runs into him in the lobby, gives him a hug, and is sort of pointing him in the direction of where she believes he's going into his room. The defendant is in the area. The defendant starts yelling and screaming and swearing at Ms. Sullivan. Ms. Sullivan responds in kind. Essentially, for the most part, the Sullivan sisters see very little of Mr. O'Keefe throughout the remainder of their trip to Aruba. And we also hear testimony from the children that shortly after this, or immediately after this, there is an approximately 20-minute screaming match going on between Mr. O'Keefe and the defendant within their hotel room in front of the children. Now, you'll also hear testimony from the defendant's phone in regard to, and from another individual's phone in regard to that Aruba, in regard to text messages of an amorous nature that she had with Mr. Brian Higgins, who was at the waterfall, and also at the residence on 34 Fairview, because he was friends with homeowner Brian Albert, but he was also friends with Mr. O'Keefe and had also met the defendant. And throughout the course of those amorous text messages, there is references that the defendant makes to that incident in Aruba, as she purported to be Mr. O'Keefe cheating on her. She insists that he was making out with Marietta Sullivan in that lobby as opposed to her giving him a hug. And makes repeated reference to that within the contents of those text messages as well. Now, you'll hear testimony from a number of different other individuals, Mr. Michael Trotta, who has a supervisory role with Canton Department of Public Works. You'll hear from Mr. Louis Tutris, who has a supervisory role with regard to IT, in regard to certain video that was recovered from the town of Canton, as well as from a temple located along the route that the defendant traveled, both away from Fairview that evening, as well as to Fairview from the waterfall, away from Fairview to Mr. O'Keefe's residence on Meadows, and then later in the morning at 5 a.m. If you recall, Ms. McCabe, I anticipate, will testify that she receives the call from the defendant about 4:53 in the morning. The defendant then drives around Canton for some perceptible half-hour or so period of time prior to even getting to Ms. McCabe's. And what I submit the evidence, or what I anticipate the evidence will show, based on sort of the tracking of the phone records, testimony you'll hear from Lieutenant Brian Powell of the state police from these VoLTE records and RTT accounts, that the defendant, while she's using her phone, is driving in the direction of Fairview Road prior to going to Mrs. McCabe's house, where she meets Mrs. McCabe and Ms. Roberts. Now, again, you'll hear testimony from a number of different troopers who were involved in the investigation. With regard to this case, you'll hear from Trooper Michael Proctor and Sergeant Jerry Mechanic of the State Police. You'll hear from Lieutenant Brian Tull. You'll hear some testimony from Trooper Joseph Paul, who's in a specialized unit within the State Police called PAWS for short, but essentially a collision analysis and reconstruction section within the Massachusetts State Police. His examination of the vehicle, his examination of the scene, his examination of specifically some Toyota texture, because Lexus is essentially owned by Toyota or vice versa. So there is some data that he's able to recover from that and back the vehicle up based on its known locations and travel. He cycles, and essentially opines, anticipate he'll opine that around 12:45 in the morning, when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle travels over 60 feet in reverse at over approximately 24.2 miles per hour. Now, you'll hear testimony, as I said, from a number of different troopers, as well as from a number of different analysts from different labs. Included within that is Ms. Maureen Hartnett, who collected items from the vehicle, the defendant's vehicle, including the taillight, sort of housing from that vehicle, pieces of the taillight that were discovered in sort of front grass, front street area. There is a specialized team called CERT team. You'll hear from Lieutenant Kevin O'Hara, who has a supervisory role in relation to that. And then later on that day of the 29th, he, along with Lieutenant Tully and a number of different members from his CERT team, were searching for evidence within the mounds of snow in front of that house, as the blizzard is still ongoing at this point through sort of the afternoon hours. Among the items that they locate is a sneaker. When Mr. O'Keefe is transported to the hospital, he's found to only have one sneaker on his feet. They find the other sneaker in that area of the body. They find various pieces of taillight. And as is wont to do, over the course of the following days, temperatures rise, rainstorm that comes in, and the snow melts. Over those successive days, there are additional pieces of taillights that are eventually discovered in that area of the front wall on the street. Now, from these different pieces, Ms. Hartnett also locates a cocktail glass that's located on the bumper, or the rear area of that scene, and she locates a human hair on the back of that defendant's vehicle as well. Now, the cocktail glass on the bumper, you'll also see surveillance video from the waterfall, and Mr. O'Keefe is observed on that surveillance video essentially walking out of the waterfall with a cocktail glass in his right hand. Same right hand that has minor injuries to it, and the same right hand that's attached to his right arm that has abrasions and lacerations that are observed by the paramedics, that are observed by the doctors at Good Samaritan, and are observed by the medical examiner as well. We'll hear testimony from another analyst, Christina Hanley, about the forensic consistency between the drinking glass that was in the defendant's bumper and the drinking glass pieces that were found on scene in 34th Fairview. You'll hear her testimony in regard to pieces of red and clear plastic that were microscopic in size that were found within Mr. O'Keefe's clothing. consistent, in her opinion, I anticipate she testify with the same pieces of plastic contained within the defendant's taillight. We'll hear from an Ashley Ballard, who works for the lab as well, and how she fit the various pieces of broken taillight from the scene together and over that taillight housing, finding them to be consistent with each other as well. We'll hear testimony from Andre Porto, who does essentially DNA analysts for the lab. And samples that were DNA samples that were taken from the taillight, from the clothes of Mr. O'Keefe, the broken drinking glass that were consistent with Mr. O'Keefe. Those items were also sent, the taillight releases, taillight DNA was also sent to the Independent Lab, Voting Technologies, located in Northern Virginia. And you'll hear from an analyst there, Mr. Nicholas Bradford, indicating that the DNA on the defendant's taillight, in his opinion, is consistent with that of Mr. O'Keefe and inconsistent with Trooper Proctor and Sergeant Buchanan, who were the two preliminary investigators and primary investigators when it came to this case. You'll also hear from this test chart from that Bodie Laboratories in regard to some mitochondrial DNA that she examined in regard to that hair that Ms. Hartman found at the Buffalo Park, in her opinion that it was consistent with that of Mr. O'Keefe as well. Lastly, you'll also hear from Dr. Irene Sfortibello and Dr. Renee Stonebridge of the Office of Chief Medical Examiner in regard to their various examinations. Dr. Stonebridge is a neuropathologist. She essentially examines brain findings. Dr. Irene Sfortibello is a forensic pathologist who does the sort of autopsy and medical examination of Mr. O'Keefe's body. You'll hear about the variety of sort of injuries that she observed over Mr. O'Keefe's body from him. In particular, you'll hear testimony in regards to lacerations to the right back of the scene. You'll hear testimony in regards to an initial sort of skull fracture that occurs to the back of the head, and then sort of a radiating skull fracture that goes throughout his skull, which then leads to subdural hemorrhage, or essentially bleeding on the brain and swelling of the brain, which then causes a condition called ecchymosis, which then sort of leads to the swelling of both of Mr. O'Keefe's eyes, as observed by the initial response. You will hear various testimony about sort of issues in regard to the pancreas, how that's indicative of hypothermia. Now, again, as I said, this is the first of two times that I have an opportunity to address you directly. And I thank you very much for your attention today, and I thank you for your participation and your close attention as we go through all of the witnesses and all the evidence. That second time that I do get to address you, what I'll be asking you, based on the evidence, again, as the board has instructed you, you are the sole arbiters of the facts of this case. You are the ones who find what the facts, I reiterate that, the facts, and what the evidence demonstrates in this case. What I submit to you at that time, that second time, is that the only true and just verdict based on that is that the defendant, Karen Reed, is guilty of murder in the second degree, striking the victim, Mr. O'Keefe, with her car, knocking him back onto the ground, striking his head on the ground, causing bleeding in his brain, swelling, and then leaving him there for several hours in a blizzard, with temperatures in the teens, wind swirling around, snow piling up on his body, until she comes with Mrs. McCabe and Mrs. Roberts just after 6 a.m. And that she is also guilty of vehicular manslaughter, operating under the influence of liquor, and that she is also guilty of leaving the scene after causing death. Thank you very much for your time.
All right. Thank you, Mr. Lally. Mr. Petty?
Thank you, Your Honor. May it please the court. Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Kent on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Kent, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. Good morning again, ladies and gentlemen. As I previously told you, my name is David Yannetti. I'm an attorney with an office in Boston. Together with attorneys Alan Jackson and Elizabeth Little, it's truly my privilege and my honor to represent Karen Reed during this trial. From a very early juncture in this case, you will question the Commonwealth's theory of the case. You will question the quality of the Commonwealth's evidence. You will question the veracity of the Commonwealth's witnesses. And you will question their shoddy and biased investigation, a faulty investigation that led to Karen Reed sitting here today. You will learn, in short, that the police did no real investigation of this case, and you will question why. You will question why the investigators had such tunnel vision. You will question why they focused solely on Karen Reed, someone with no ties to the Canton Police Department, as opposed to the well-known and well-connected Albert family of Canton, a family that was never treated as suspects by the investigators in this case. Boston police officer John O'Keefe was found mortally injured on Brian Albert's front lawn. His body was in full view and almost right below Brian Albert's bedroom window on his front lawn. He was found wearing only one sneaker. You'll learn that Brian Albert was a Boston police officer as well, and that he was a trained first responder. Brian Albert was notified that another police officer was injured and unresponsive on his front lawn, and Brian Albert did nothing. His sister-in-law, Jennifer McCabe, and other civilians were on his property that morning after John O'Keefe's body was found. Police, EMTs, firefighters, police cruisers, an ambulance, fire truck, lights flashing, and first responder Brian Albert never came out of his house. Equally important for you will be the fact that the lead homicide investigators never went inside the Albert home that night. You'll learn that Brian Albert's brother, Kevin Albert, is a Canton police officer. It was obvious very early on that the Canton police should not be investigating the death of a man found on the property of the brother of a Canton police officer. So it was decided just about from the start that the Massachusetts State Police should take complete control of this investigation because the Canton police were conflicted out. Now, that sounded good at the time, but you'll learn that two major problems arose. First, despite the fact that they obviously had a conflict of interest, the evidence will show that the Canton police still had their hands in this investigation. You will find it astounding. But Canton police officer Kevin Albert, the reason for the conflict of interest in the first place, was continually updated about the status of this investigation while it was going on. Second, and equally troubling, is that the lead state police detective who was assigned to this case was a man named Michael Proctor. Michael Proctor, you will learn, is one of the many people in Canton with deep ties to the Albert family. Michael Proctor's own mother refers to the Alberts as the Proctor's second family. His own sister's wedding, Michael Proctor was in the wedding party with Colin Albert, and he sat at the head table of that wedding with members of the Albert family. That's the man who was chosen to lead the investigation into the suspicious death on the property of Brian Albert. That's the man who gave updates to Canton police officer Kevin Albert while the state police were supposed to be investigating what had occurred at his brother Brian Albert's house. You'll learn that right from the jump, Michael Proctor predetermined the outcome of this case. He never stepped foot inside the Albert home on January 29th, 2022. Never checked out whether there were any signs of struggle inside that home. He never called for crime scene technicians and other specialists to look for blood or other trace evidence within the home. He never asked Brian Albert for permission to go in the home and take a look around. Michael Proctor never applied for a search warrant to go in that home. Instead, he focused immediately and exclusively on Karen Reed, the outsider. You will learn that no one in the Proctor family has ever called the Reed family their second family. No one in the Proctor family had been in a wedding party with anyone from the Reed family. Karen Reed was a convenient outsider. She was most definitely not from Canton. But how did Michael Proctor feel about her? How did he treat somebody he was investigating at a point in time when he should have been keeping an open mind, focusing on obtaining all possible evidence so that he didn't miss anything? Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone. He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing or what he was saying. And he was revealing his true thoughts about Karen Reed to his friends, not what he put in his sanitized police reports, his true feelings to his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator, Trooper Michael Proctor, right from the start, called Karen Reed names he would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself. He told his friends that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe. We'll learn that one of Michael Proctor's high school friends commented to him that with a dead body on the front lawn, the homeowner in this case is surely going to catch a lot of grief. And do you know what Michael Proctor's response to that was? One word. Nope. And he explained why. Michael Proctor assured his buddies that the homeowner would not catch a lot of grief because, quote, the homeowner's a Boston cop too, end quote. That one sentence, ladies and gentlemen, in Michael Proctor's own words, will explain a lot to you about how this investigation was conducted. You will be able to evaluate whether Trooper Michael Proctor treated Brian Albert and his family differently because of who they are and their relationships between his family and theirs. You will evaluate whether this investigation was on the up and up. You will decide, as a result, how valuable or worthless the prosecution's DNA evidence is or is not, in light of who controlled that evidence. You will learn that Michael Proctor's fingerprints are figuratively all over this case. His fingerprints are all over the Commonwealth's evidence. You will learn that Michael Proctor showed up at Karen Reed's parents' house in Dighton to interview her during the afternoon of January 29th, only hours after John O'Keefe's body was found dead on Brian Albert's front lawn. You'll learn that Michael Proctor had her Lexus SUV towed from her parents' home. But you'll also learn that he wrote a search warrant in which he falsified the time that he took that SUV. He swore under oath that the vehicle wasn't towed until 5:30 p.m. But you'll learn that we obtained surveillance footage that he didn't know we would get. And that surveillance footage exposed that Michael Proctor's words in that sworn affidavit were a lie. Michael Proctor had that vehicle for about 90 minutes before he claimed to have taken it. And folks, you will learn that the timing is important, very important. Because when John O'Keefe was first found on Brian Albert's front lawn, the police thoroughly searched that yard for potential evidence. And it wasn't just one officer, or two, or three. There were at least 4 officers that searched that front lawn. And that morning was the beginning of a snowstorm, but there wasn't yet much snow on the ground when they were searching that lawn. It was light out by the time they did the search, and it was getting lighter. And during that thorough search of Brian Albert's front lawn, the number of pieces of taillight that were found by a minimum of 4 officers looking for evidence was 0. It was only later in the day when the snow was really starting to accumulate that the police miraculously started to find pieces of taillight on the property. The police only started to find pieces of taillight after Michael Proctor had seized Karen Reed's car. They only started to find pieces of taillight after Michael Proctor had possession of her taillight. You'll learn that Trooper Michael Proctor then kept going back to the Albert residence after that day, and he claims to have kept finding pieces of taillight on multiple occasions on multiple different days. And in addition, a good week after John O'Keefe's death, Canton Police Chief Kenneth Berkowitz, an older officer on the brink of retirement with probably not the best eyesight, he supposedly was happened to be driving past Brian Albert's house. And by the way, Brian Albert is someone with whom Chief Berkowitz is also good friends. And this older man allegedly spotted yet another piece of taillight from his moving vehicle. This was yet another piece of taillight that was somehow missed by the trained specialists who had previously and thoroughly searched the property. Another piece of taillight that Proctor supposedly missed in the many times he went back to the property. Michael Proctor claims that he kept finding pieces of taillight right up until February 18th of 2022, which was nearly 3 weeks after John O'Keefe was found dead on Brian Albert's home. You will learn that there is no competent evidence that Karen Reed's taillight shattered at Brian Albert's property in the early morning hours of January 29th, 2022. To the contrary, you'll learn that when Karen left John at Brian Albert's house, she drove back to John's house on Meadows Ave across town in Canton. At John's home, where he lived with his 2 adopted children, Karen was drifting in and out of sleep, but she woke up for good in a panic sometime around 4 a.m. because John hadn't come home. And that was not like him at all. He had never done that before. Karen had a sinking feeling that something was wrong. Something was seriously wrong. So she got back into her Lexus. She backed up out of the garage to leave the driveway. And when she did, the right rear taillight of her Lexus struck John's parked vehicle in the driveway, and her taillight cracked. That was the same taillight that the prosecution now claims was broken outside the Albert residence hours earlier at 12:30 a.m. But we have video evidence that the taillight was actually broken at 5 a.m., many hours after the prosecution needs that taillight to have been broken. There is, of course, no video of the taillight being broken at Brian Albert's house. You will eventually conclude that that's because the taillight was not broken there. Importantly, you will learn that there was an eyewitness who arrived at 34 Fairview after Karen got there with John O'Keefe in the early morning hours of January 29th. And that eyewitness, Brian Nagel, who's the brother of Julie Nagel, who was at the after-hours party that night. He had a clear view of Karen's SUV. Brian Nagel confirmed that there was no damage to her taillight at that time. Karen was sitting in the driver's seat with her hands at 10 and 2. And Ryan Nagel confirms that while Karen was inside the car, John O'Keefe was not. John O'Keefe was also not outside the car at that time. You will ultimately conclude there's only one other place he could have been. Now, going back to that 5 a.m. video from John's driveway, you will see Karen back up her Lexus and strike John's car at about 5 a.m. when she was leaving John's house to go out to look for him. And you will know that she struck his car at 5 a.m. because you will watch that video closely. You will witness that the wheels and the hubcaps on John's car are jostled and moved by Karen's SUV. And you will conclude that that video depicts exactly when Karen's taillight was cracked, long after she dropped off John that night at 34 Fairview. And you will learn that part of the reason that Karen's Lexus hit John's car was that Karen was panicked at that time. Where is John? Why didn't he come home? What happened to him? And you will learn that she was racking her brain for what possibly could have happened. And like many of us, was worried about the worst. Did I hit him? Could I have hit him? That was what she was saying, both to herself and to other people later that morning when she went back to 34 Fairview. She couldn't think of anything else that made sense. She certainly didn't consider in a million years that someone from within the Albert home could have beaten up John and left him to die on the front lawn. Now, that was over 2 years ago. Karen didn't know then what you will learn during this trial. Karen didn't know that Brian Albert's sister-in-law, Jennifer McCabe, left the after-hours party at Brian Albert's house sometime after Karen pulled away. She didn't know that after Jennifer McCabe dropped off some people elsewhere, she returned to her own home. Karen didn't know that Jennifer McCabe climbed some stairs in her home and eventually made it into her bedroom with her cell phone. Karen didn't know that Jennifer McCabe settled in at 2:27 in the morning on January 29, 2022, and typed a Google search that she would later delete. 2:27 in the morning was over 3 hours before John O'Keefe's body was found on Brian Albert's lawn. 2:27 was over 3 hours before anyone knew or suspected that John O'Keefe was missing or hurt or in trouble. And at 2:27 in the morning, you will learn that with no one watching her, thinking she was alone with her thoughts, not worrying that anyone would know what she was doing, Jennifer McCabe typed in the following Google search: how long to die in the cold? Now, she misspelled the first word, so the actual search was how long to die in the cold, but you'll get the point. You will ask yourself, why would somebody Google how long does it take for someone to die in the cold, unless that person knew someone who either was in that situation or would be in that situation? You will question during this trial, who was it who actually did die in the cold at some point that night, sometime after Jen McCabe was asking Google for an answer to her question? And you'll learn that the answer to that question was John O'Keefe. The medical examiner in this case will testify that one of the causes of John O'Keefe's death was hypothermia. John O'Keefe died in part because he was left to die in the cold. Now, the Commonwealth will try to dispute the timing of that Google search. They'll try to claim that there were only 2 Google searches at 6:23 and 6:24 a.m. after John's body was found. But one problem for the Commonwealth will be that we have retained Richard Green, one of the leading computer forensic experts in the country. Rick Green has forensically analyzed Jennifer McCabe's phone, both manually and using every appropriate type of computer software to solve this issue. Rick Green will confirm for you that Jennifer McCabe did indeed make that search at 2:27 a.m. And another problem for the Commonwealth is that you will hear and see other evidence that will confirm that Jennifer McCabe is lying when she denies making that Google search at 2:27 a.m. You will conclude that before she went to bed, if she went to bed that night, Jennifer McCabe wanted to know just how long it would take for someone to die in the cold. And a big question in this trial for you will be, when was John O'Keefe left to die in the cold? I expect the Commonwealth will try to persuade you that he was left there sometime around 12:30 a.m. because they're going to try to prove to you that Karen Reed hit him and that his body stayed there the entire night until first responders arrived at 6 a.m. and his body was taken to the hospital. But you will learn that there are big problems with the Commonwealth's theory of this case. You will learn that there were 6 people at that after-hours party at Brian Albert's house, all of whom left by the front door and would have been confronted by John O'Keefe's lifeless body on that lawn if he was actually there at that time. Those 6 people walked out the front door to 34 Fairview, walked to their cars, either in the driveway or parked in front of the house. Brian Albert's sister-in-law, Jennifer McCabe, was there. Her husband, Matthew McCabe, was there. ATF federal agent Brian Higgins was there, who was also Brian Albert's friend. Sarah Levinson, a friend of Brian Albert Jr., was there. Julie Nagel, another friend of Brian Albert Jr., was there. And Caitlin Albert, Brian Albert's daughter, was also there. All of them leaving the residence. Each of those people left 34 Fairview in Canton, where Brian Albert lived. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2", nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe laying. Not one. And you know who else saw no one laying outside in the early morning hours of January 29th? The snowplow driver in charge of plowing the street for the city of Canton. And this is another big problem for the Commonwealth. You will learn that Michael Proctor, here's that name again, wrote a report where he claimed that the DPW supervisor had told him that Fairview Road had not been plowed that night. Proctor's total investigation on this issue consisted of one phone call and no follow-up. He just submitted his report that simply said the road hadn't been plowed that night, perhaps thinking that no one else would follow up either. But you'll learn that when it came to finding out the truth, it's not that Proctor couldn't find the truth, it's that he wouldn't. But fortunately, you'll learn that we would, and we did. You'll learn that within weeks after January 29th, we sent our investigator, a former Medford police officer named Paul Makowski, to the Canton DPW to try to get to the bottom of this. Paul Makowski talked to the same supervisor at the DPW, a man named Michael Trotta, whom Proctor claimed had told him that the street hadn't been plowed that night. You'll learn that Paul Makowski found out that Michael Proctor was not telling the truth. You'll learn that Michael Trotta from the DPW told Paul Makowski, our investigator, that the street was indeed plowed that night, and that the name of the plow driver was Brian Loughran. So Paul Makowski tracked down Brian Loughran. He asked Mr. Loughran if the state police or any investigators had ever spoken to him. And the answer came back, no. You will then learn what Brian Loughran had to say about what he saw and didn't see that night, and you will be shocked. Brian Loughran told Paul Makowski that he was driving a big snowplow in Canton that night. You'll learn that the nickname for it at the DPW was Frankenstein, because it had a lot of spare parts and it had been around forever. Brian Loughran told Paul Makowski that when he plows the streets of Canton in Frankenstein, he's very careful. He makes sure to check not only the roads in front of him, but also the yards to the side of his plow. He makes sure not to hit a fire hydrant or a tree or an animal, or heaven forbid, a person lying in the snow. He's always on the lookout. You'll learn that Brian Loughran passed by 34 Fairview in his plow, traveling right by Brian Albert's front lawn at 2:30 in the morning. You'll learn that Brian Laughlin confirms that at about 2:30, when he went by that house, John O'Keefe was not on that front lawn. So you'll learn that about 2 hours after the Commonwealth claims that Karen Read somehow incapacitated John O'Keefe, an eyewitness confirms that not only could it not have happened, but it didn't happen. But you'll learn that Brian Laughlin also provides some other troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 in the morning and seeing no body, he showed up again at the entrance to Fairview Road, intending to make another pass down it with his plow. This time, however, at about 3:30 in the morning, he looked down the street and he saw that parked right next to Brian Albert's front lawn, right in the very area where John O'Keefe's body was later found at 6 a.m., Brian Laughlin saw a Ford Edge parked on the side of the road. You will learn that the police have done zero investigation to discover whose Ford Edge that was. You'll learn that members of the Albert family drove Ford Edges. You'll learn that the police to this day claim not to know who was parked right next to the area where John O'Keefe's body was later found. You'll learn that while investigators on this case, including Michael Proctor, completely ignored the snowplow driver who went right by the Albert residence, the defense not only tracked him down and interviewed him, but the plow driver actually took our investigator on a ride back past the residence to explain the precise route that he had taken on January 29th. You'll learn that some other curious things were going on in the early morning hours of January 29th. Curious things that the police in this case utterly failed to investigate. For example, after people left the after-hours party at Brian Albert's house on January 29, Brian Albert claimed that he had no contact with anyone but his wife until he was woken up in the morning. But you will learn that he was ultimately confronted by the fact that his phone records revealed that he had actually placed a phone call to ATF agent Brian Higgins, his friend, the same friend who had been at his house earlier that night. And that was at 2:22 in the morning. You'll learn that Brian Higgins called him back 17 seconds later, and they connected 22 seconds on their cell phones. You'll be asked to consider just how long 22 seconds is and what could be said and discussed during that long of a phone call. You will consider that phone call in the context of the other curious things that were going on during the early morning hours of January 29th. You will learn about the following in chronological order. 2:12 a.m., Jennifer McCabe arrives at her home. 2:22 a.m., Brian Albert calls Brian Higgins. 2:22 a.m., 17 seconds later, Higgins calls him back, and Brian Albert and Brian Higgins are on the phone together for 22 seconds. 2:23 a.m., Jennifer McCabe climbs the stairs to her bedroom. 2:27 a.m., Jennifer McCabe searches on Google, how long to die in the cold. 2:30 a.m., plow driver Brian Laughlin confirms there was no body on Brian Albert's front lawn. 3:30 a.m., Brian Laughlin confirms that a Ford Edge was parked right where John O'Keefe's body was later found. The Commonwealth will not be able to successfully dispute any of those facts, yet I expect that they will persist in asking you to convict Karen Read anyway. You will learn that there are other major problems with the Commonwealth's theory. You'll learn that when John O'Keefe was found, he did not look like he had been hit by a car. You'll learn that he looked to have been attacked and beaten up. You'll learn that John O'Keefe was a large 6'2" man who, if positioned behind a Lexus SUV, would have had his torso completely exposed to the rear of that vehicle, including to the taillight. You'll learn that no part of his torso was injured. There was no bruising, no ridges, no scratches, no punctures. You'll learn that his chest and hips and legs were pristine, despite the Commonwealth's contention that he was hit by a 6,000-pound vehicle. The evidence will show that what was not pristine was his right arm. You will take one look at that arm, and you will conclude that a car did not cause those injuries. The injuries to John O'Keefe's arm appear to be consistent with scratch marks and claw marks, marks that make it look as though an animal had attacked his arm. But you won't have to rely just on your common sense when you look at those photos. You'll hear from an expert forensic pathologist who is world-renowned, who has personally conducted thousands of autopsies. And he will testify that those marks are consistent with scratch and claw marks and bite marks from an animal, including a German Shepherd. You'll learn that on January 29th of 2022, Brian Albert's family dog, Chloe, was a German Shepherd. You'll learn that Brian Albert has admitted that this dog is not good around strangers. You'll learn that on January 29th of 2022, John O'Keefe would have been a stranger to that dog. And you'll learn that Chloe had been the beloved family dog for the Alberts for 7 years. The Albert family loved Chloe. But strangely, as we discussed this dog today, the Albert family doesn't have its beloved Chloe anymore. You'll learn that Brian Albert was called to testify before the grand jury regarding this matter in April of 2022, and that he did testify about his German Shepherd, Chloe, during that grand jury testimony. And you'll learn that not long after that testimony, Brian Albert and his family rehomed their beloved family dog. They gave away their family dog, and Chloe, the German Shepherd, is therefore now gone. Now, the Commonwealth will try to take your attention away from all of these troubling facts and try to persuade you not to consider their shocking lack of investigation of anyone else, not to consider John O'Keefe's injuries, not to consider the fact that multiple people left the residence and saw no body, not to consider the fact that the snowplow driver was specifically looking at 2:30 a.m. and there was no body there, not to consider the fact that 2 people in the house were communicating at 2:22 a.m. but denied speaking to each other for 22 seconds, and not to consider the fact that one of their witnesses, who was also present at the home, was unusually curious at 2:27 a.m. about how long it would take for someone to die in the cold. Commonwealth will instead try to persuade you that Karen Read supposedly had a motive to kill John O'Keefe because they were not getting along. You'll hear about their trip to Aruba over New Year's Eve and that Karen was upset that John had been flirting with another woman. And you will hear that Karen considered exploring her options after that trip, which led her to a get-together at one point with ATF federal agent Brian Higgins, although that never went anywhere. But you'll also hear that in January of 2022, after the Aruba trip, and not long before January 28th and 29th, John O'Keefe was making long-term plans with Karen, including a family trip with her and the kids, and also another trip with Karen and another couple for months into the future. And you'll see video of how John and Karen were interacting on the night in question. You'll see for yourself how they looked at each other from the video at the waterfall that night. Nobody who saw them that night saw anything wrong. There was nothing wrong. I mean, like any couples, occasionally they would bicker or disagree, but you will hear zero evidence of any domestic violence in that home whatsoever. John never raised a hand in anger toward Karen, and Karen never raised a hand in anger toward John. That simply wasn't who they are. You will conclude the notion that Karen Read chose the start of a snowstorm to suddenly become violent out of the blue for the first time and intentionally kill her boyfriend by hitting him with a car and leaving him there with a house full of people inside is patently ridiculous. You will also learn that what's not ridiculous is that someone, not Karen Read, ambushed John O'Keefe. Somebody probably didn't mean to kill him, but somebody went too far. You'll learn that Trooper Proctor failed to investigate motives that other people had to harm John O'Keefe. You'll learn that Proctor failed to investigate anything or anyone who was in the Albert residence that night. You'll learn that he failed to investigate the antagonistic relationship between members of the Albert family and John O'Keefe. You'll learn that apparently nobody investigates the Albert family of Canton. Remember, on day 1, Trooper Proctor was asked whether the homeowner, Brian Albert, would catch a lot of grief. And Trooper Proctor himself said, "No, homeowner's a Boston cop too." So folks, the trial is now about to start and the witnesses are about to start testifying. On behalf of Karen Read, I ask that you do 2 things during this trial. First, I ask that you pay attention to all of the evidence. The way trials work, the prosecution gets to present its case first. They conduct their direct examinations first. So we respectfully ask that you wait for us. We will get to cross-examine their witnesses, and you will find that cross-examination is the key that unlocks the truth. Wait for us. You'll be glad that you did. Second, I ask that you keep your eye on the ball. You have one job and one job only to do during this trial, and that job, quite frankly, is not to solve this case. Your only job during this trial is to determine whether the Commonwealth, the prosecution, has proven to you each and every element of the crimes they have charged, beyond a reasonable doubt, to a moral certainty. The prosecution will fail to prove this case to a moral certainty. They will fail to prove this case beyond a reasonable doubt. You will reasonably doubt their case because their theory of the case does not make sense. You will reasonably doubt Their case, because Karen Reed was framed, and the evidence shows that, despite the fact that the police never ever investigated that angle of this case at all. Because the prosecution will not prove their case beyond a reasonable doubt to a moral certainty, we will stand before you again at the end of this trial and ask that you find Karen Reed not guilty.
All right. Thank you very much, Ms. Giannetti.
Or maybe push it sidebar?
Yes.
Ugh. Chloe says that the trial comes into better context when you see the pretrial hearings and see all the exculpatory evidence that Bev wouldn't allow. There's a whole video of the Higgins. And Chloe, what are the Higgins doing? Challenging John to a duel. They inside the house. They had cameras in the house. Baby, they was trying to fight. From that little I just heard, they might lose again. Okay? Karen's other attorney is doing opening statements this time around. AJ. That's Jackson, though, right? That's who been going head to head with Brennan. Because I would imagine that Brennan's gonna do the opening for the state as well. Y'all, I'm glad that we watched it. Thank you, Beta. I think that was a great exercise to do. It was a lot that was said in there though. Like, she think he got hit by a plow. They are saying that she said things that may have been admissions, could have been questions. The tail light piece is throwing me though. And I'm just taking this all with a grain of salt, right? I'll take the other opening arguments that we heard on Tuesday as gospel. Let's call it that. I'll take that as gospel. But how do they know it's missing pieces of tail light? How much room did she have to back into him and knock him out his shoes to the point where he suffers a skull fracture and with a brain bleed? Like, that's you gotta hit somebody kind of hard like that. You know what I'm saying? And so I'm just having a hard time visualizing somebody back into a person with a little bit of room and knocking them over, and they dying in a yard. So that mean that the yard would have some type of like tire tracks in it, right? Maybe a little tire tracks, maybe not. I don't know. But all these people coming out the house and they don't see him. You got a first responder in the house. He ain't came out the house yet, but he lying about who he talking to. You got this man Higgins and the McCabe's. You got the McCabe's having phone conversations with you over at your house, and then she take her little stuff up to bed and just do too much. I heard Googling how long does it take to die in the cold because she's still drunk. And then you got a Ford Edge parked outside of the house at 3:00. Was that 3:00 or was it like 3:30? Because so what did he do? Like, what was his route though? Because he said the snowplow man said he went by 2:30 and with nobody out there. So John was still in the house at 2:30. Okay. Here's my other question. If Karen hit John's car that was parked at the driveway at the house, wouldn't the tail light fragments be at the house? Like, why wouldn't they? Or did somebody go pick up her tail light fragments and take them back over to his house and drop them off? Like, what's going on? Oh, Brian Higgins is the FBI agent that Karen was flirting with. Then he ghosted. Right. See, I ain't really get the bar story. Maybe they'll lay out the bar story for me next week. And all the injuries are above the chest, except was he squatting down or something when she hit him? Like, y'all, that man said he was out in the yard with one shoe on. Like, I will say I seen people get knocked out their shoes. But for a car to hit you and knock you out your shoe, you got to be hit kind of hard or your shoe was never on for real. You know how you just throw on some shoes and you run outside real quick? You may not tie them up. Like, I don't know. He have no tire tracks on his body, no tire marks, no glass from the car. And I don't even know if that's glass. It's like plastic, right? Like plastic shards on them. Did he have like I said, like I would expect somebody. I was hit by a car too, y'all. When I was like 8 or 9 years old, somebody was riding a bike and I jumped on the pegs and a car came and hit us and I fell on the ground. We fell off the bike. And so all I had was like a skid mark. So I would anticipate like scratches on the body, but not a true like puncture wound. Okay. They took his shoes off because, you know, the theory is when a person gets hit by a car, it knocks them out their shoes. It couldn't have. How much room did she have? Because she was gonna have to go at a fast speed to knock him out his shoes. She cracked it at his house, but was intact but damaged. Then they shattered it and planted the evidence later. That car had to be going faster than 20. Exactly, Shay. The car had to be going at least 45 miles per hour to knock him out his shoes. He was hit by a 7,300-pound vehicle. They did, y'all. Child, well, this was an interesting chain of events. So, well, Karen Reed starts on Tuesday. We got, did they ever come back? Let me see if they ever came. Okay, yeah. We can watch the end of, that's Turtle Boy. Let me make sure. I'm just trying to make sure we didn't miss nothing. I don't think we did, though.
I ask that you just allow me to make the representation and leave it there.
Okay, so we back Tuesday, y'all. We back on Tuesday. All right, so I'm gonna let y'all enjoy the rest of y'all day. I'm going to go and do a few things before my children start arriving from school, and I will see y'all later. Going over there and catch Lori. Going over there and catch Lori. I had actually I think that was Lori that was playing on this screen before it's swapped. I think Lori had popped on. Yeah.
So these prior emails, we saw a person purporting to be Karen Walker using Lori Daybell's phone number, writing to brother Daybell, right?
Yes.
But here we see someone again from this same email now purporting to be Charles Vallow.
She said nothing for Lori. All right, but Lori is on, y'all. So go on over there and watch Lori, and I will see y'all tomorrow.
And had you heard of the Preparing the People conference before?
I had.
Is that something that Lori Vallow was involved